I'm Catherine Park, an immigration attorney in the United States. I've talked about the southern land border on this channel and some of the issues confronting non-citizens who arrive without a visa and make a claim for asylum. In this video, I'll discuss a recent amendment to the law regarding the northern border, the U.S. border with Canada. Some non-citizens seeking asylum cross into the U.S. from Canada or into Canada from the U.S. Either way, the new law will determine where the non-citizen is allowed to make a claim for asylum during the first 14 days of the journey. They might have a preference for the U.S. or Canada, and the preference will be noted by the direction of their travel. But the non-citizen's preference is irrelevant under the new law, because the first country that they land in, whether it's the U.S. or Canada, will get to decide the asylum claim. You have nothing. Nothing to threaten me with. Nothing to do with all your strength. Don't worry. I'm going to tell you where they are. Both of them. And that's the point. You'll have to choose. He's in Ottawa, Ontario, and she's in Niagara Falls, New York. So non-citizens will actually get the opposite of their preference. If they're traveling from country A to country B, they'll be sent back to country A to seek asylum. Any non-citizen who is physically present in the U.S. or who arrives in the U.S. is permitted to apply for asylum under the Immigration and Nationality Act, but one of the exceptions in the INA is the safe third country exception. If a safe third country exists where the non-citizen's life or freedom would not be threatened, and the U.S. has a bilateral or multilateral agreement with a third country where the non-citizen would have access to a full and fair procedure for seeking asylum or equivalent temporary protection, the non-citizen has no right to apply for asylum in the U.S. The U.S.-Canada border law is a bilateral agreement. It's called the 2022 Additional Protocol, additional because it expands the geographic application of the Safe Third Country Agreement, which went into force in 2004, but only governed official ports of entry such as airports. But with the 2022 Additional Protocol, the Safe Third Country Agreement, the STCA, governs ports of entry and the areas between ports of entry, including certain bodies of water. The new law went into effect on March 25th of 2023. And although someone might file a federal lawsuit to block the law, what such a federal lawsuit would get you is delay and perhaps a chance to advocate that the law be changed. But the result won't be all of a sudden a non-citizen who doesn't qualify for asylum gets asylum. That's not what a federal lawsuit accomplishes. For instance, in the case of the previous version of the third country transit ban, which is a similar type of law governing the southern land border between the U.S. and Mexico, a federal court did issue a nationwide injunction to stop the law. And when President Biden was elected, people thought he might repeal the third country transit ban. What the administration did was announce that the law would be revised and reissued. Okay, it's now called the Circumvention of Lawful Pathways. So the Biden version is somewhat less harsh, and it's supposed to be temporary, lasting only 24 months after it goes into effect. And it's not in effect yet, I should mention that. But after it's effective for 24 months, they could renew the law. So we see what could happen. The Biden administration now is conducting notice and comment rulemaking for the Circumvention of Lawful Pathways, which means they're dotting the I's and crossing the T's to make the law really stick. And it doesn't get any more permissive toward migrants than the Biden administration, the Biden-Harris administration. The only sensible way to live in this world is without rules. And tonight, you're gonna break your one rule.
I'm considering it.
No. There's only a few minutes left, so you're gonna have to play my little game if you want to save one of them.
And?
As an example, the president recently came out in favor of a path to citizenship. Not just lawful status, but citizenship for farm workers who might be here on an H-2A temporary work visa or who are undocumented. The abuse of migrant workers by the agriculture industry in the U.S. has become so heinous and commonplace and seemingly unstoppable that advocates have come out in force in favor of a path to citizenship, if only to stop the abuse of workers, which is some of the worst labor trafficking that we thought could not even occur in modern times, but it is occurring. However, the Farm Workforce Modernization Act, which would have provided a path to citizenship for migrant farm workers, was supported by Democrats, but the bill was defeated because there wasn't enough Republican support. Do I really look like a guy with a plan? I'm not a schemer. I try to show the schemers how pathetic their attempts to control things really are. So when I say that you and your farm worker citizenship bill was nothing personal, you know I'm telling the truth. So let's discuss the process. A non-citizen is apprehended in the U.S. after coming in from Canada and within 14 days of entry makes a claim for asylum or other protection due to fear of persecution or torture in their home country. At that point, an asylum officer will conduct a threshold screening interview to determine eligibility to apply for asylum in the U.S. If they're not eligible, they'll be removed to Canada to pursue asylum. But if they're not disqualified for asylum in the U.S. but did land in Canada first, they still might be able to pursue asylum in the U.S. if they're not already in transit after being removed from Canada and if any of the following exceptions applies. First exception, they're a citizen of Canada or have no nationality and are a habitual resident of Canada. Second exception, they have a family member in the U.S. who is either a spouse, son, daughter, parent, legal guardian, sibling, grandparent, grandchild, aunt, uncle, niece, or nephew who's been granted asylum, refugee status, or other lawful status in the U.S. However, non-immigrant lawful status doesn't qualify, such as H-1B technology employees, and visitor status under the Visa Waiver Program doesn't qualify either. Third exception, the non-citizen's family member in the U.S. is at least 18 years old and has an asylum application pending at USCIS Immigration Court or is on appeal in a federal court. Fourth exception, unmarried, under 18, and no parent or legal guardian in the U.S. or Canada. Fifth exception, arrival in the U.S. with a validly issued visa or admission document other than for transit, or if they're required to have a visa to enter Canada but not the U.S. Sixth and last exception, USCIS has unreviewable discretion to keep a non-citizen's asylum application in the U.S. If the non-citizen does qualify for an exception, the asylum officer will conduct a credible fear interview to determine if the non-citizen has a well-founded fear of persecution or torture in their home country. The federal regulation describes the credible fear interview process, which I covered in detail in a previous video. It's the same credible fear interview process. It's the same regulation. If the asylum officer makes a negative credible fear finding, the non-citizen can appeal the finding to an immigration judge. The immigration judge's jurisdiction is limited, however. Only the negative credible fear determinations are reviewable by an immigration judge. What's not reviewable is the asylum officer's determination that the non-citizen doesn't qualify for an exception and must be removed to Canada to pursue asylum. But before the non-citizen can be removed to Canada, a supervisor has to concur with the decision. Also, a non-citizen who is ineligible for asylum is also ineligible for withholding of removal or relief under the UN Convention Against Torture. However, they could be removed to Canada to pursue that relief.